Now we're getting into topic number 9, international contracts. And what we're going to do is look at basically domestic contracts, a contract in British Columbia, what the binding elements are, and things like that. And once we've got a good grounding in contracts, then we'll look at international contracts. So a contract is defined as a promise or set of promises the law will enforce. That comes from Lord Herschel, who in the late 1800s had a court case where it looked like he was going to have to provide a definition of a contract. And he said it was far too complex to do that. So he said, suffice it to say that a promise or a set of promises the law will enforce. I've looked at numerous textbooks and I've finally written my own for BADM 107, and I have come to the conclusion that the best way to look at it is that there are 6 binding elements of a contract. There has to be an offer, there has to be an acceptance, there has to be consideration going both ways. There has to be an intention to actually enter into contractual arrangements. There has to be capacity and legality. So what we're going to do is we're going to look at those very briefly, because this should be in effect review from BADM 107. And we also have to take into consideration that the International Sale of Goods Act is a convention which governs contracts for the sale of goods, obviously, over boundaries of nations. But other than that convention, contracts are handled by judge-made law. So in other words, a business in BC enters into a distribution agreement with G'day Mate in Australia. That is an international contract, but there's no statute, there's no convention, there's no treaty that has any bearing on that. The municipal law has to be applied, and then the question becomes, is it the law of BC or is it the law of Australia? And then you get the conflicts of law situation we've already talked about. The next slide, 108, is just a cartoon for the fun of it. But then we get into slide 110 and we look at an offer, and all we have to do about an offer is say that it must be communicated. Okay, well, that's fine. Let's just leave it at that. Pretty straightforward. But once an offer is made, is it sort of there for all time to be accepted, or is there some way that the offer can come to an end? And in fact, there are a number of ways the offer can come to an end. On screen 109, we list 5 of them, and gosh, anybody smell a potential Part B exam question? First, the offer can lapse in 2 ways. It can lapse after a time specified, or if no time is specified, then it can lapse after a reasonable period of time. Now we're talking here about offers, okay? Once there's a contract, contracts do not lapse. Contracts do not come to an end except by performance or breach, okay? So I want to sell you my car. I say, let me know by 5 o'clock Friday. Saturday you call up and you say, I'll buy it. And I say, oh, I'm sorry, I've already sold it. And you said, hey, you made an offer and I've accepted. No, the offer lapsed at 5 o'clock on Friday. Straightforward. What happens, though, when you don't put in a specified time? Well, the courts will assume that an offer lapses after a reasonable period of time. And what is reasonable? The courts have said that is a question of fact, which means you have to look at the individual circumstances of the contract itself. I want to sell you my car. Well, in this COVID environment, people that have lost their jobs are trying to sell vehicles, and so there's a lot of them for sale, and it might take months for the car to be sold. So if I made you an offer and you said, let me think about it, I'd better be very cautious about selling it to somebody else until I have dealt with you. Because if I sell it to someone else and you come back and say, I accept, and you say, oh, but it's been 3 weeks and I didn't hear back from you, so I sold it already, well, technically you could sue me for breach of contract. I sold my car twice, to one person who now has it and to you, and I have no car to give you. So why would you sue? Well, let's say you wanted to buy my car for $7,000 because it was an incredible deal. Okay. But I sell it to somebody else and then you accept. And I say, oh, I'm sorry. Well, yeah, I'm going to be sorry because I've sold it twice. So you go out and you buy a car of comparable quality, okay, and you spend $12,000. well, you could have bought it from me for 7, but you wound up spending 12 to get the same type of car at the same quality. Now you've suffered $5,000 in damages. So you could buy that other car, sue me, and get $5,000, and that way you come out where you should have come out. 3 weeks, a month and a half, 2 months, the courts will look at it and decide what is reasonable, and that's a very dangerous situation to be in. But what about if it's flats of raspberries? I have 100 flats of raspberries, I'll sell them to you for $1 a flat. And you say, let me think about it. Well, you call me back 4 days later and you say, I'll take them. Well, hey, 4 days later, I don't have raspberries anymore. I have raspberry juice or raspberry mold. Okay, it's perishable, very perishable. And so what is reasonable would be a question of fact, and in that situation, much, much shorter time period before the offer lapses. A lot of textbook would say the third way an offer can lapse is if either the offeree or the offeror becomes insane or passes away. And in my BADM 107 textbook, I say, no, that's not quite right, because if someone passes away or becomes insane, the offer doesn't lapse. It's a lack of capacity, okay? And one of the binding elements isn't there, and so the offer becomes null and void. The other way that an offer can come to an end is if the offeror revokes it. So I say to you, I'll sell you my car for $7,000. And you say, let me think about it. Then somebody else wants to buy it off me for 9. Well, I'd rather sell it to them for 9 than you for 7. So I sell it to them, and I see you coming down the street. So I just wait around the corner, and you walk around the corner, and I go, I revoke my offer. Okay? And you say, no, I wanted to buy your car. Well, it's too late, because I've revoked my offer before you've accepted. And then that brings the offer to an end. The other way that an offer can come to an end is through a counter offer. I say, I'll sell you my car for $7,000, and you say, no, but I'll buy it off you for 5. And I say, no, not interested. And you say, okay. You made an offer at 7, I'll buy it at 7. Maybe I don't want to sell it now. And so I say no, and you go, hey, no, you made an offer at 7 and I'm accepting. Well, no, I made an offer at 7 and you made a counter offer at 5, and that counter offer extinguishes my offer. And it's no longer available to be accepted unless I reiterate it. Then there's these things like called crossed offers. And we have to be really careful here. Used to be a lot of correspondence with respect to offers and acceptance for contracts was done by mail. And then we had fax machines, and we have, all sorts of instantaneous communications, and so it's not such a big deal anymore. But now we have email. Okay, so I talked to you about buying and selling my car, and we part ways. And I'm walking away, and I think, I think I will sell my car. So, and I send you an email. I offer to sell my car for $7,000. At the exact same time, you're thinking, I want that car. So you send me an email. I offer to buy your car for $7,000. And then, bing! Oh, look, great! We got a contract, and away you to go to get the $7,000 by way of certified check. In the meantime, somebody comes up and says, I'll buy your car for $8,000, and I sell it. And then you come with the certified check for $7,000, and you say, here we go to complete the contract. And I go, what contract? And you say, well, our contract, because, we got a deal. And I say, oh, no, I made an offer to you, but I never heard back from you. And you made an offer to me, but you weren't accepting my offer. You just said, I offer. So we had crossed offers. So until somebody actually accepts, those crossed offers do not create a contract. That's the first binding element. No, let's back up. We have to look at screen number 107, because there it says offer, and then just below it says invitations to treat or invitations to do business. What's that about? Goods with a price tag, or goods on a website with a price, or goods in a catalog with a price. Those are not offers. They look like offers, but they're not offers. Those are merely invitations to somebody to come in and make an offer to you. So those goods with a price tag are invitations to do business. You come in and make an offer to me, and I agree to sell. Okay. Okay, now we're getting on to acceptance. Two things. Acceptance must be positive, and you cannot stipulate silence for acceptance. The acceptance, if I say, yes, I'll buy your car, but I want new wheels on it. Well, that isn't acceptance because it's not positive enough. I don't know, and you don't know whether you're going to get the new wheels or not. Cannot stipulate silence. I've got an anecdote on that one. I had a client who wanted to get into international business. He wanted to be an international lumber broker. And he went to Japan. I incorporated a company for him. He went to Japan and he found a Japanese company that wanted to buy lumber. And they gave him a deposit. And he ripped back to Vancouver. And then he went up to a logging operation and he said, here's the deposit. Ship the lumber down to the loading docks in Vancouver. And the Japanese company sent over a ship, picked up the wood, paid him by letter of credit. He paid the balance to the lumber company, and woohoo, he's a lumber broker. He started off very small because when he started off, he had to mortgage the farm. And that's a phrase that we quite often say, oh yeah, I went into business and I had to mortgage the farm. What it means is you mortgage yourself to the hilt, not that you've got a farm. But in his case, he actually did mortgage the farm because he had a farm in Alberta and it was leased out and had somebody running it, but he wanted to get into international business. So he mortgaged the farm and used that money as the down payment. Anyway, he made that deal and he made a little bit of profit and he called me up and he said, woohoo, I'm a lumber broker. So then he went to Taiwan and he did the same thing. Now he had a little bit more money, so he bought some more and got a bigger deal. And what he wanted to do was he wanted to go to all the various countries and get to travel and do business so that it would he'd be making a profit traveling rather than paying out money. Anyway, went off on one trip, and this huge multinational firm out of Australia sends him a fax message back when we had fax machines, and it went into his in-basket in his office where nobody worked because he was a sole operator and didn't need a receptionist. So it sat there for about a week. When he got back, he read it, and it said, we require 1 million board feet of lumber of such and such a grade, and we'll pay this amount for it, and if we don't hear back from you, we will assume we have a deal. And he looked at it and he went, oh no. He said, I don't have enough money to put a down payment to get that kind of a deal done. And he said, and I don't have enough time. And oh no, and they've sent the ship. Oh no, he said, I'm ruined. And he called me up. And I said, no, don't worry about it. They cannot do that because Australia is a common law jurisdiction. We're a common law jurisdiction. And in our jurisdiction, and there's as well, you cannot stipulate silence. If we do not hear back from you, we will assume we have a deal. So anyway, I wrote a letter to the company, a very pointed letter saying you cannot do that. And I got a call from a very outgoing, "G'day mate, how you doing, eh?" Australian businessman at about 5:30 in the morning because of the time change. And he said, I got your letter. He says, back off, mate. He said, no problem here. He said, they wouldn't hold him to the deal. And I said, okay, out of curiosity, you're a huge multinational firm. How can you have a contract that stipulates silence as a means of acceptance? And he says, no. He says, we deal with a lot of lumber brokers. And he says, we send out an offer. We don't want them to waste time sending back an acceptance. We send out the offer. If we don't hear from them, then we assume we have a deal. So if you have a working relationship with someone, you can stipulate silence. But if this is a first time or a one-off, you cannot say, this, and if I don't hear back from you, we assume we have a deal. It turned out to be really good. What he did was, the Australian fellow, he said, what's the problem here, mate? And I said, well, he's a small lumber broker, and he didn't have the down payment, and he was traveling, and he didn't get the message in time. And the fellow says, "Oh, don't worry about it." He says, "We'll divert the ship somewhere else." And he says, he doesn't have enough money for the down payment. He said, "Oh, well," he said, "how much does he need? We'll wire him the funds." So I not only got to tell my client that he was still in business, that he was not going to be held to that contract, but I got to tell him that he had the funds for the down payment. And sometimes you shoot yourself in your foot when you did that. I did such a good job for him that eventually he went to work for that company, moved to Australia, and I lost the client. But it was a good story. So you cannot stipulate silence. That brings us to the third binding element of a contract, and that's consideration. Now, there's this thing called bilateral contracts and unilateral contracts. The acceptance by silence that we were just talking about is a unilateral contract. They made the offer. They didn't want to hear back. What they wanted you to do was accept the contract by performing the task. Okay, send the lumber. Bingo, we got a contract. That's a unilateral contract. If he doesn't send the lumber, then he's not in breach of contract because of the cannot stipulate silence part of it. But the difference is between a unilateral contract and a bilateral contract is when I'm selling my car to you. I'll sell you my car for $7,000. You say, "I accept." Do we have a contract yet? Because I haven't given you my car and you haven't paid me. Yes, we do have a contract. Okay? A lot of people say, no, we don't. And it's not in writing, so it cannot be a contract. But no, a verbal contract is enforceable. It's just a little harder to prove. But we don't deal with proof in this course. Okay? We just deal with the legalities. So a verbal contract is enforceable, but wait a minute, there's any consideration. Yes, there is. The consideration is my promise to give you the car and your promise to pay me. I mean, it has to work that way. Otherwise, when would I ever give you goods on 30, 60, 90 days if we didn't have a contract? You're promising to pay me later. So, there's no consideration going both ways, so we don't have a contract, so I give you the goods and you don't have to ever pay me and I cannot sue you? Don't think so. So obviously bilateral contracts are an exchange of promises, okay, for the consideration. Consideration is generally the price for which the acceptance or promise of the other person is bought. Have to distinguish consideration from a gratuitous promise, okay? So I say, "I'll sell you my car for $7,000. You say, "Oh, no, I can't afford it. I'm a hard struggling student. Oh, I can't afford it. I really need a car." And so I think, "Oh, poor person. Okay, I tell you what, I'll give you my car." And you say, "Oh, I accept." Well, do we have a contract? I made an offer. You've accepted. We both have capacity, hopefully. I intended to give you the car. You intended to accept it. It's totally legal because I own the car. So it sounds like we have a contract, but one of the elements is missing, consideration. Okay? Your consideration is you're getting the car. What is my consideration? I don't get any consideration under that arrangement, except that warm, fuzzy feeling in the pit of my stomach knowing I've helped a struggling student. But that isn't enough to be binding at law. So what I've done is I've made a gratuitous promise. So I say, "Oh, okay, I'll give you my car. Come by my place 5 o'clock Friday." Well, 5 o'clock Friday, you come by my place and you say, "Okay, I'm here to pick up the car." And I say, "Oh, sorry, my niece wanted it, so I sold it to her for $100. And you go, "Hey, we got a contract." No, we don't. You cannot sue me. It was a gratuitous promise. If I give you the car, I have now transferred title to you. And I go, wait, no, I don't want to do this. It was a gratuitous promise. Give me the car back. Too late. Okay? I've given you the car. But up until the time I give you the car, I can change my mind. Okay, that's a gratuitous promise. Adequacy of consideration, the courts do not care whether you make a good bargain or a bad bargain, as long as there is a bargain there. There was a news article, I wish I'd kept it, from the Los Angeles Times. A fellow was walking around his neighborhood, and a neighbor has a garage sale. The fellow walking by, and he looks down, and he looks at this sketch. Looks at it, and he goes, "I think that's a Picasso." So he says, "How much do you want for the sketch?" And the guy goes, "I don't know, make me an offer." He says, "$20. The guy thinks $20 for an old sketch. Oh, this is great. And so he pays him the $20 and he picks it up, takes it out of the frame, and he goes, "It is a Picasso." Right? And the fellow says, no, hey, that's I didn't mean that. I want that back. You didn't give me enough money. Courts don't care. Okay, $20 consideration. And so we get into a situation where quite often you can have a nominal consideration to bind a contract. Okay, so I'll give you my car for something, or I'll sell you my car for something I can't afford it. Okay, I'll give you my car, and you go, no. I'll tell you what, you give me your car, I'll give you $1. And I go, oh, okay, $1, right? And I go, no, that's not enough. That's not adequate consideration. Well, yeah, it is as far as the courts are concerned. All right. You often see in court cases where somebody has paid a peppercorn or a tom tits in order to cement a deal. So a peppercorn is that little corn, corn that you put in a grinder and you put pepper on your eggs. One peppercorn is all the courts require for it to be considered consideration and binding contract. All right, so the next topic is the use of a seal, and I've got some samples, and I'm just going to go and get those, so we'll have a short break. Seals have been used in history for thousands of years, even longer in the Far East. A seal signifies that the document is your act and deed, and you are the covenantor, and it is a covenant. It was called this because it was so important, because it related to land initially. And it became such a significant act, putting your seal on a document, that eventually consideration was no longer necessary to bind you to that agreement. So Ben Counter on slide, what the heck is this, 111, would sign above his name on the signature line, and then a red sticker would be put beside his name, and then he would be deemed to have signed that document under seal. This is a guarantee, and by that promisor, the guarantor says to the creditor that the guarantor will pay if the original debtor fails to do so. That's what the issue was in the Sharn importing case. So let's look at the Royal Bank versus Kiska case, because the interesting thing is law is so bizarre that when you read the cases you go like, could that really have happened? What happened was there was a young fellow named Kiska who had a hairdressing salon, and he was in financial difficulties and he needed money from the bank. And the bank said, well, sure, we'll lend money to you in your business, but we want some more security. Perhaps your brother could give a personal guarantee. Well, his younger brother ran a pizza shop with another fellow. So the brother comes to the bank and he signs a guarantee, and then later finds out that his brother cannot pay and the business is going to go under, and the bank is going to sue him for the money. And he's absolutely aghast, because he said, look, at the time you said this was just a formality, that was very unlikely that I'd be called on to have to pay. And they said, well, you're going to have to pay anyway. And they pointed to the red seal beside his name on the document. And he said, that isn't on my copy. That wasn't there when I signed the agreement. Does not understand the significance of that comment until later. But he was so upset that he grabbed the guarantee from the bank manager's hand, and he ripped off the part with the signature and the seal, and he began eating it. And the security guards are called in, and they come in and they're trying to get it out of his mouth, and he's eating it. And eventually, they say, "Look, you're going to have to, sign another one." So they bring out another guarantee, and he signs it reluctantly. This time, there's a seal on the document. He won't pay. They wound up in court. And it goes to the Court of Appeal in Ontario. Now, 2 judges say he has to pay. Even though the seal was not on the document originally, they said he had to pay because there was consideration. The bank agreeing not to sue the brother was good consideration to bind the younger brother to the contract. The third judge judge dissented, and he was one of the best judges Canada's ever had. He went on to go into the Supreme Court of Canada. His name was Chief Justice Laskin. Anyway, Laskin says they said that they didn't sue, and so that forbearance was enough to bind the contract. He said, but when you look at the contract, in the contract it says nothing about forbearance. And the contract says this is the entire agreement between the parties. And he said, therefore, he thought it was wrong for the judges to say that something outside the contract, when that's supposed to be just the contract, could be used to say there's consideration there. And he was correct. Okay, the other judges just made a mistake. Well, over the years, other judges in other provinces, particularly in BC, have followed Laskin's dissent rather than following the judgment per se. Okay, now we talked about applying, following, considering, distinguishing, and overruling court cases. Why didn't the BC judge just overrule that case? Well, a BC judge can't overrule a law from another jurisdiction. Okay, they can overrule a law from their own jurisdiction, but there was nothing to say that they couldn't follow the dissent and just say that the majority judgment was incorrect. So in BC, we've actually followed Laskin's dissent, but Kiska had to pay, unfortunately, and I'm sure that the law has probably changed. So there are lessons that we can get from the Kiska case, and I've put them on slide 113, and pardon me, I'm going to read them because it's a lot to memorize. The general rule is that the absence of consideration, the seals must be affixed to the contract at the time or before the contract is signed for it to be binding. So Kiska's the younger brother. Kiska, when he signed that contract, the seal wasn't on there. It should not have been binding on him. If the seal is not affixed to the contract will not be binding unless the court can establish consideration in some other way, i.e. like the forbearance. Okay. It is not necessary for the seal to be a red wafer. What are they talking about? Well, they're talking about these sort of things. You buy these sheets and you just peel off one of these little stickers and you put it on the document, and bingo, that's your seal. In modern times, we'll talk about where that came from in a minute. But anyway, it's not necessary for it to be a red wafer as long as there's some act that indicates the intention to be bound. So, I don't have a red wafer, like what do I do? Well, you can take a red pen and you can do this, or you can take a black pen and write sealed and circle it, or whatever you want, as long as there's some definite indication that you intended to sign under seal. Some documents, like personal guarantees that the banks use all the time, are printed ahead of time, okay? And right beside the signature lines, it says affix seal here, or affix seal. And Laskin turned his mind to that, and he said, does the mere fact that that's printed on the form indicate the signer's intention to sign under seal? Or does it merely indicate that further formalities are required? And he decided that it really indicated that further formalities were required. Sometimes at the bottom of a document it'll say signed, sealed, and delivered. Or whereunto we have affixed our seals. Does that mean that the document's signed under seal? No, not if something else hasn't been done to indicate that they were signing under seal. And then there's another case, not from Kiska, but from earlier BC law, where someone put their thumbprint, a red thumbprint, beside their signature line. And then the other party said, hey, he was sealing the document. And the court said, no, not unless he said, I am sealing the document. Okay. Otherwise, the thumbprint could be just an indication of identification. All right. So those are the rules that come from the Kiska case. But I want to talk about this whole idea of seals a little further. And that is, back in ye old English days when people could not read and write, or very few of them could, what happened when they were buying and selling land? Well, they would have a deed drawn up by somebody they trusted, and it would be read to them, and then it would be read to the other party by someone they trusted. And once the people were comfortable that that reflected their agreement, there would be signature lines at the bottom, and they would, sign their names. No, they would not, because they can't read or write, right? So they would put an X. One party would put an X, and the other party would put an X. And then if there was a disagreement and it went into court, there was a problem of proving whether they actually signed that document and whose X's was whose X's were whose, who the X belonged to. And so, the judge would say, "Is that your X, Mr. Holden?" "Yes, my lord. Either that one or, maybe that one." And so there were inequities occurring. There was one case we took at law school, and I wish I had saved it. It was just unbelievable. It was way back in the 1600s or 1700s. This fellow's signing the document, and he puts his X on there, and he turns to his elder son, and he says, "Son, remember that this date, that X there, the top X is mine." And the son, typical son, "Yeah, sure, yeah, Dad, right." "No, son, I really want you to remember. This is really important. Remember." Yeah, Dad, sure, yeah, I'll remember." Father picks up a piece of wood and goes whack and hits him on the side of the head, and he goes, "Ow, what did you do that for?" He said, "So that you will remember." Okay, well, it turns out that a couple of years later, there is a lawsuit. They're in court. The farmer has to prove his signature. And he says, "Yes, the top signature is mine." And the judge says, "Well, how can you be so sure?" And he says, "Well, I'm sure, but also I have a witness." And they call the son. The son's on the stand. And the son says, "Oh, yeah, the top X there on that date, that's my dad's signature." And the judge says, "How can you be so sure?" The kid goes, "See the scar here? My father hit me on the side of the head to make sure that I would remember." And the judge says, "That's good proof, right?" Well, you can't go around hitting people on the side of the head to make sure that, they remember they signed documents. Otherwise, after a while, you don't remember anything, right? But it showed the difficulty of signing documents in those days. So what began to be done was families had family crests. I mean, the people that owned land, okay, the people that were a little more wealthy. If you were just a worker on the farm, you were like a peon, a serf. So what the farmer would do is he would sign the document, and then he would melt some wax on the document, and if he was rich enough and he had a signet ring, he would go and put his family crest into the signet or into the wax. If he wasn't rich enough, then he would have it on a little stick, okay, and he'd go became a very formal way of signing documents, and I'd be kind of interested. I like it when I have a class room, because how many of you know what your family crest looks like? When I was 16 years old, my father took me down to a heraldry shop, and we searched the Holden family tree, and we came up with a shield, like for doing battle. And there was a helmet up here with a moorcock on the top of it. A moorcock is a very important English bird. I'm not quite sure why, but it is. Trust me. Anyway, on the shield there were 3 capes, like Zorro's capes. 3 capes in the shape of scallop shells in red. And I thought that was pretty significant because in my family there were 3 kids. And in my dad's family, there were 3 boys, and in my dad's family, there were 3 boys. So I thought the 3 was really significant. Down here, you can see our family motto: neither timidly nor rashly. Neither rashly nor timidly, actually. What's that mean? It means, well, I'll battle you on the field and I'll kill you, but I'll do it, without any anger. And I thought that was pretty good for a lawyer. I'll sue you, but not rashly. Well, eventually, my father's brother went to England and retraced our family history, our tree, all the way back to our ancestral castle. All right, well, okay, it wasn't a castle. It was a large manor. It wasn't so much a manor as a cottage. Okay. It was a cottage with a dirt floor. I am not in line for the throne. But I thought, hey, the dirt floor was kind of neat because John F. Kennedy, when he traced his family tree back to Ireland, it was to a cottage with a dirt floor. So I thought it was kind of neat. Anyway, he traced our family tree, and he found out that our crest wasn't like that. Like, there were very many branches of the Holden family. Our crest was actually a little different, and he had pewter mugs made, okay, one for himself and one for each of his brothers. And I can bring it up close. Okay, there we go. You can see that there's the shape of the shield is different, and that there's these red markings on it. And in the middle of the markings is a mailed fist, an armored fist. Now, I like that. For a lawyer, an armored fist, that's great. And again, there's a helmet at the top, and I don't know if there's actually a bird on this one. No, there isn't. Okay. Anyway, he had 3 of these done, and then he gave one to my dad. And when my dad was older, he said, you might as well have this. And so I have it, and I treasure it because it's our actual family crest, and that's what would be on the signet ring imposed on the wax to seal a contract. Why does the mug have a glass bottom? There's actually a legal reason for that. Okay? This is what you drink beer in the pub. That's why I like it so much. No, I'm just kidding. Anyway, back in ye old England days, when England had this huge empire around the world, the empire was held together by the merchant marine and the navy. And so enlistment in the merchant marine and the navy was incredibly important. So much so that we had what was called press gangs. And they would go down and they'd skulk around London, and they would go into bars and they would see who was drinking. And then when the person's leaving the bar and walking down the street, or the tavern or pub, whack, they'd hit him on the head, and he'd wake up on the deck of a ship the next day, and the captain would come out and say, "Congratulations, you're in the Navy." Well, there's a lord that's down slumming, and he goes into a tavern, or pub rather, and he has a whole bunch of drinks, and he's inebriated, and he walks out and whack, they hit him on the side of the head, and they put him on the deck of the ship. Out comes the captain and says, "Congratulations, you're in the Navy." "Oh, Lord Herschel, oh my gosh, oh, I'm so sorry." They had to turn the ship around and sail back so that he could get off. If you weren't Lord Herschel and you're on that ship would be gone at sea for a year at least, maybe 2. So by the time you got back, you were literally in the Navy, right? Anyway, Lord Herschel, they take him back. Lord Herschel is so upset when he finds out what's happening that in the House of Lords, he demands that the law be changed so that there has to be consideration given to the person. And he has to accept that consideration to have a binding contract for him to be in the Merchant Marine or the Navy. And I said him because back in those days, they didn't have women on ships. So anyway, they changed the law. So what the press gangs would do now is they would go into the pub and you'd be drinking away. And when you weren't looking, they'd drop a crown in your drink. And they'd go, "Hey, what's this? Oh, a crown. Oh, you've accepted our money. You've accepted the consideration. The contract is complete. You're in the Navy." So they put glass bottoms on the mugs. And they would go, "Hey, let's have another round. Okay, bottoms up." Have you ever heard that phrase? Bottoms up? Bottoms up. Bottoms up. And you would look, and if there was a crown in there, you'd put the drink down and you'd walk away. Okay. You didn't accept the money, no contract. Okay. Imagine that. Bottoms up. And glass bottom mugs has to do with consideration and the law. I haven't put that on the exam before, but it's got to get on the exam sometime. Maybe this year. Anyway, eventually people were signing contracts but didn't have a family crest or didn't know what it was, and so they began using these little red wafers instead of wax. Back in those days, they had... why did they use red wax? And why did the red wax suddenly turn into red wafers? Well, because there were 2 types of candles readily available in England. Red candles and white candles in the churches. Red candles is the blood of Christ. White candles is the purity of Christ. Well, they used the white candles, but they were translucent, and so you couldn't see the crest. So they began using the red wax because it had dye in it, and you could see the crest. Okay, the other interesting thing is when you go to the bank and you have checks made out, so that you can write out checks. On the signature line, they put an X where you're supposed to sign. Where does that X come from? It comes from ye old England times when people used to put X's on the signature lines. Isn't that kind of neat? I think that's kind of neat. Anyway, enough about that. So people sign the way I have Benton Counter signing on slide 111. But what about a corporation? Okay, well, a corporation uses a corporate seal that looks like this. Okay, and I'll see if I can tilt my screen down so that you can see how it's signed. They just put the paper in there and they go like this and they emboss it down, and I put pencil on this one so that you can see it a little bit better. See, and it has the word seal and then the name of the company around, and that's how a corporation would sign a document. A little international information here regarding corporations signing documents. You have to be a little careful because in the province of British Columbia, in order to be bound without consideration, a corporation has to sign under seal. In other jurisdictions, not necessarily so. The mere fact that the corporation signs under the signatures of their authorized signatories means they're bound under seal. So, for example, Section 22 or 23 of the Saskatchewan Business Corporations Act says that they're bound without a seal. Okay, in BC, not the case, and I haven't, but I will put in another screen which shows those two laws because that's international problems cropping up. You enter into a contract and the company from another jurisdiction signs it, isn't receiving any consideration. Are they bound to it? Well, in Saskatchewan, yes. In BC, no. Okay. All right. Now, in the Sharn importing case, you'll remember that the question was, did Babchuk sign this contract under seal? And in British Columbia, they had a seal on it, and yes, it was binding because BC law applied. In Alberta, even though he signed under seal, the law there is different because you have to actually have a notary public or a commissioner for the taking of oaths witness the signature of the person signing. Okay, all right. So that's seals. And we are now on to slide 117, and we start talking about international contracts. So a contract is international. The second, it is cross-border. And although the feeling would be that it would have to be between a BC business and a Washington State business, or a BC business and German business, or a BC business and a Mexican business, just cross-border in Canada makes them international. And we saw that in effect in the Sharn importing case because it involved BC, Alberta, and Quebec, and the laws in all three jurisdictions are different. Okay, so but there is one convention that covers the international sale of goods, and it is international in nature. All the countries that were signatories to the convention and then had an enabling legislation. If there's a contract between businesses in those countries, the CISG automatically applies. Well, this can be a little disturbing. If it was a BC business and a California business, unless you take steps to make sure that the CISG does not apply, your contract may well be governed under civil law as opposed to common law, because the International Convention on the Sale of Goods, there were so many civil law countries involved in the negotiation of it that in order to get it passed, most often it followed the civil law with respect to offers, acceptance, consideration, and intention. Okay, the CISG does not apply to contracts where there is a capacity issue or a legality issue, because legality, oh wait, that's like, is it legal? And every country is different. Okay, capacity, is a person of legal age in BC the same as a person at legal age in California? No. BC, you're an adult when you're 19. California, you're an adult when you're 21. So obviously they couldn't get any agreement on those last two elements, but the first four elements are covered by the CISG. For example, the common law mail rule is different than the mail rule under the civil law. Well, civil law applies, common law doesn't. The parole evidence rule in BC applies to contracts unless it's a CISG contract, in which case the parole evidence rule doesn't. And so you can see you can wind up with different answers with respect to the applicability or enforceability of a contract, depending upon whether the convention applies or not. If it's not the sale of goods, okay, then obviously the CISG does not apply, and you're back to the situation where you'll have a conflict of laws, and then the court has to figure out which law applies. All right, now we're going to stop there for now, and we'll deal with the rest of that later. So now we're looking at the International Sale of Goods Act in BC, which adopts the convention because it's enabling legislation, as we saw in slide 16. So a closer look at the actual convention is necessary. There have been a lot of signatories to the convention, and on slide 117 you can see the dark green countries are the ones that have ratified it, the light green ones have signed but not yet ratified it. And then the gray countries are those that don't follow it. And the surprising thing, I think, is that most common law countries appear to have done so, and yet India is absent from application of the CISG. The convention breaks down into four parts. The first part is the general provisions, and I will post the international sale of goods online, or at least give you a site where you can look at it. The general provisions are things like Article 1, where it says the convention applies to contracts of sale of goods between parties whose places of business are in different states. Okay. Now, states is defined as a country, ergo the CISG would not apply to a contract of sale between a business in British Columbia and a business in Ontario. Okay, that's considered to be in the same state. It goes on to say what in Article 2, what goods are covered, which when you first think about it, you think, well, what's the problem here? But for example, goods of a personal, family, or household nature, a contract for sale of those is not covered. Goods that transfer from one party to another by operation of law or authority of law. What's that mean? Well, that's when a company goes bankrupt and the assets then transferred to a receiver. Stocks, shares, investments are not covered, but that makes sense because goods are tangible personal property, whereas stocks and bonds are intangible. Ships, vessels, hovercraft, and aircraft are not covered by it. And electricity isn't covered by it. I'm not quite sure why that was in there, but I guess there's so much electricity transferred across borders that they had to decide whether electricity, those little electrons that go along the copper wire, are goods or not. So that's the general provisions. In Part 2, you get into the actual formation of a contract. And this is the part where offer and acceptance, consideration, and intention to interlegal relations is covered, but legality and the capacity are not, because those are particular to the various countries. Okay, so On slide 118, a sale must be international, and then the parties may opt out of the CISG with a choice of law clause pursuant to Article 6, and that's really important. A sale is defined as the exchange of goods. When you have goods and services, they look to see whether the services makes up most of the component, in which case the sale of goods falls outside of the convention. As I mentioned, illegality and incompetency is not covered. It's left to domestic law, so you could have the application of the CISG and still have a dispute which would have to be decided pursuant to the most significant relationship doctrine because it falls outside of the Act. The parole evidence rule. What is the parole evidence rule? Well, the parole evidence rule is a doctrine from common law where if you have a contract negotiation and the idea is that the terms shall be reduced into writing in a contract, and then there's a dispute as to the contract, some verbal representations will not be allowed to add to or contradict the contract. So let's put this in context. Peak Performance Pontoon says they will sell 1,000 pairs of skis to G'day Mate in Australia. And G'day Mate says, sure, we will buy those, but we want you to include 10 free pairs that we can use for demonstration purposes. So the contract is reduced to writing, and in there only the sale of the 1,000 skis are mentioned. And G'day Mate says, well, what about the 10 free pairs? And Peak Performance Pontoon says, well, we're not selling those to you, so this is a purchase and sale contract, so, we wouldn't put it in there. And, Croc Dundee down there goes, oh, yeah, okay, oh, yeah, that makes sense. Then the sale takes place, the skis are transferred, and G'day Mate says, hey, where are 10 free pairs? And Benton Counter says, oh, I rethought that, and 10 pairs at $1,000 a pair is like $10,000. So, that's too much. You're going to have to buy those. And Croc Dundee says, well, wait a minute. No. That was part of the deal. Well, that contract, because both countries are common law jurisdictions, the parole evidence rule applies, which means that oral agreement cannot be used to attack the contract itself. So Croc Dundee could not say, okay, look, I'm canceling the contract, I'm sending your skis back, because they're bound by the contract. And that's how the parole evidence rule works. A real life example, I had a client, a young man, he was an up-and-comer in Vancouver. He was really well known in the business community, and he was a mover and a shaker. Well, his father was a driver mechanic for Budget Rent-A-Truck. And his father had 3 driving convictions for drunk driving and was fired from his job. He had a mortgage on the house, and so this was quite serious for the family. Well, the son helped his father negotiate an agreement to buy a fish and chips restaurant. Okay. And he came in with his father into my office, and he said, here's the purchase and sale contract. We would like you to handle the transaction. Remember, one of the things you should do is get to your lawyer on time, which means if you have an appointment at 2 o'clock, get there at 10 to 2. That's not what I mean. If you're entering into a contract, don't sign on the dotted line, then go to your lawyer and say, how'd I do? Anyway, I was looking at the contract, and I felt kind of awkward because the son obviously felt very proud that he had been able to step in and help his father who was in trouble. I don't know what it's like for young ladies, but young men, or at least I felt, really happy and fulfilled when I could finally do something for my father that he could not do for himself. It was like that, finally I'm a real man. Anyway, I can remember the day. But anyway, this fellow was feeling that way. And so I felt kind of awkward because I was looking at the agreement and there were no financial statements attached to it. So finally I thought, okay, well, I've got to deal with this. So I said, All right, and now there are no financial statements attached. So how do you know this business is making money? And his answer was, oh, well, they told us. And I went, oh, okay. Oh, wait a minute. No, you've got a written contract here with a clause in there called the entire agreement clause, which means no verbal representations can be used to attack the contract. What if you buy the place and it's not making any money at all? He said, no, don't worry about it. And I said, well, no, I'm a lawyer. It's my job to worry. And the fellow turned to me and he said, don't worry about it. They are from the same ethnic background as we are. They were both, the purchaser and vendor were both from a certain East European country, and so there was no way that vendor would possibly cheat them. Heads up, folks, most people are honest and forthright, but there's, if somebody's going to cheat you, it doesn't matter whether they're the same ethnic group or whether they're a different nationality or come from a different country or whatever, okay? If there are red flags popping up, make sure you cross the T's and dot the I's, because that's the only thing you can do. So I said, I highly recommend that you don't go ahead with a purchase until they provide you some substantiation. And he said, no, I want you to go ahead. And they're looking in the basement for some register receipts to substantiate that it's making money. So I wrote them a CYA letter. Okay, that's a cover your letter. And I mentioned that this was a factor. I went through the sale, and he's back in no time at all, and he's saying, that place wasn't making any money at all. I want you to sue them. Can't. Parole evidence rule. The question is, would we be able to establish that they were really perpetrating a fraud? Or would the vendor be able to say, well, it was making money when we were running it, but this fellow just doesn't know how to handle the business. Okay, that's why it's not making money. And the judge would go, case dismissed, right? So that's how the parole evidence rule applies. Now, the parole evidence rule, if you want to read something more about it, there is a portion of the textbook for BADM 107, Risky Business, that you can read, and you just contact me and I'll photocopy the pages out of there and send it to you. So anyway, Rule 8 specifically says that Article 8 rather specifically says that the parole evidence rule does not apply to contracts governed by the CISG. Offer is defined in Article 14 as a proposal addressed to a specific person, including an intention to be bound to a sale or purchase for a price. Pretty straightforward, no difference from the common law. Revocation, an offer that is not stated to be irrevocable, may be revoked at any time before the offeree dispatches an acceptance. Okay, revocation, same thing as in common law. Consideration does not apply to the CISG, therefore a promise that an offer is irrevocable is binding and are called firm offers. Here is a big difference, okay? I'll sell you my car for $7,000. And you say, let me think about it. I sell it to my niece, and then you come and say, okay, I'll buy your car. And I say, no, that was, I sold it already. Well, I'm in trouble, right? Because I made an offer and you've accepted. But what happens if I say, I'll sell you my car, and you say, I can't afford it. So I say, okay, I'll give it to you. At common law, I'm not bound to that agreement because it's a gratuitous promise. Until such time as I give you my car, I can not even revoke. I can back out of the deal any time, right? But under the CISG, if it's a business operation and I have a fleet of cars and I say, I'll sell you my fleet of cars, and I don't hear back from you, I cannot. My offer is irrevocable because under the CISG it is a firm offer. All right, so I had better put in that I'll sell you, or that I'll sell you my fleet of cars, and I don't hear back from you, I better put in a time limit so that my offer lapses. Otherwise, I'm not free to sell them to somebody else. Big difference. The mail rule does not apply to the CISG, and if you remember from BAD-M 107, if I send you a letter offering to sell you something, and you send me a letter back accepting, the question then becomes, is the contract complete when I receive your letter because acceptance must be communicated? Or is it effective when the offeree puts the acceptance in the mailbox? And the surprising thing is it's when the letter goes in the mailbox, because the post office is considered to be my agent, ergo the contract is complete when the acceptance is communicated to my agent. The rationale for that reason we don't have time to get into right now, because that should just be review. However, in the civil law system, if I send you a letter and I'm in Vancouver and you're in Toronto under the civil law system, what would happen is you would send me the acceptance letter, but the contract would not be complete until I actually receive the acceptance. Okay, so there's a complete difference there. What applies? Well, because there were so many civil law countries putting the CISG together, they outweighed the common law countries, and so the civil law concept with respect to the mail rule applies, not the common law. And the common law countries were quite upset about this, but then the answer to that was, well, okay, then just opt out of the CISG. Fundamental breach, the failure to perform, which substantially deprives the other party of what he was entitled to expect, is in Article 25, so it's both a common law and civil law jurisdiction or application. The next two, or is it three? No, yeah. The next two are really important, and that's the seller's obligations, okay? The seller must get the goods to the place of delivery. They must abide by the time of delivery, and they must turn over the documents necessary to complete the transfer of ownership. And the goods must conform with the sample or model or the way it was advertised. Okay, that's the seller's obligations. The buyer's obligation is to pay, big surprise there, eh? And to take delivery of the goods. And I think I mentioned, and if I didn't, then it was in the other course, and so I'm just going to say again, I had a client who had an Oriental furniture store, and he sold a substantial amount of business furniture to a buyer in Puerto Rico. And the goods were sent down and taken out of bond and taken to his premises, and he refused to accept them. He had paid by MasterCard, and he canceled the payment for non-delivery. Okay, and then the question arose, and my client was out of money and lost the goods. Oh, well, how could couldn't they be returned, like the goods returned? Well, they could, but then my client has paid to send them down and paid to send them back, and that would be a huge amount of money out of the purchase price. But worse still, when they were in bond and taken out of bond and delivered, they were secure. But when they were returned to the warehouse, they're no longer in bond. They disappear. Everybody stole things. I need a desk. And they just take it home, right? So my client was out of pocket, and we decided to sue the bank that canceled the credit card application, and the bank defended on the basis that, well, there was no delivery. In actual fact, delivery occurs when it goes to the place specified, not when the person accepts delivery. Okay, so we were actually able to get the client's money. The transaction was reversed on the MasterCard. Okay, so payment of price, you have to tender the money appropriately, and you have to take delivery of the goods. What happens if there's a breach? the buyer's remedies. Okay, so I'm buying, and the seller doesn't go through. Well, there's specific performance. Remember, this is the equitable remedy that I talked about. You can get an order for specific performance. You can also, if the seller says, I can't get them there by March 5th, that's when the deal is supposed to be completed. The buyer can say, okay, we're going to give you a Naschfrist notice. I'm not sure I'm pronouncing that right because it's Germanic. It's a rule that came from Germany. And they put it into the CISG even though it was just a German rule because it makes sense. Okay, the contract is canceled because delivery doesn't occur on the date. Well, if the date of delivery isn't exactly, absolutely, positively necessary, in other words, a condition of the contract, then the contract is canceled, but I don't want it to be canceled. So I say, okay, you can have another period of time for delivery. Okay. The remedy, okay, delivery occurs early. Well, I may have a problem as the buyer. Oh, good, I got it early. Oh, that's fantastic. Except that I may have nowhere to store it. So if the goods are delivered early and I'm actually just turning around and selling them to somebody else, so I want to get them and sell them, I don't want to get them and store them. So I can actually refuse delivery if delivery occurs early. Okay, I'm buying and selling and buying and selling, and they send 2,000 pairs of skis instead of 1,000 pairs of skis. And we have this arrangement where, the skis as they go through, we pay this. Well, we didn't. That's excess quantity, and I cannot afford to pay $200,000 for an extra 1,000 pairs of skis. So you can refuse excess quantities. All right, let's look at it from the seller's perspective, and this is more important to peak performance pontoons. We can actually declare specific performance. Make them take the goods because they're under contract to do so. Now, specific performance is a remedy available in civil law jurisdictions for goods, tangible property. Not very often in common law will specific performance be declared as a remedy, except with respect to land. So that's a difference as well. Pardon me. Avoidance. Okay, here's a remedy where we can say, all right, you're in default of your contract. We're going to avoid the contract. In other words, avoid it. We're going to sell. The skis are on the way to Australia, but we're going to divert them and sell them somewhere else. And then we can also say missing specifications. Okay, we send the skis, and and they say, wait. We wanted a certain number of basic skis, a certain number of intermediate skis, and then a certain amount of the advanced cruise missile skis. And you say, okay, wait a minute. In the order, there was no specification as to the number of each different type. So we've sent whatever. So we have a remedy if there was missing specifications, okay? And then there are remedies common to both parties. Suspension of performance just means, okay, we're going to suspend performance, and everything is just going to stop. All right. Not used very often, but it sort of relates to the whole concept of force majeure. Okay, it is a remedy that we have. If I have to deliver 1,000 skis per month to G'day Mate, and a fire in the building next to mine, also causes damage to my building. Oh, for the next 3 months, I'm not going to be able to deliver skis. So am I in breach of my contract? No. Performance can be suspended pursuant to the Force Majeure Act. And then the last one is anticipatory avoidance. G'day Mate says, oh, wait, you don't deliver the skis to us because, we don't have enough money to pay for it. And so what you can do is you can say, okay, well, we're supposed to deliver those skis by August 15th, you don't have enough money to pay for it. All right, so we're going to avoid the contract. And the next day, G'day Mate calls up and says, "Oh, well, wait, no, we got our money." Well, anticipatory avoidance is a remedy that is a little on the dangerous side, because what that means is we're going to avoid the contract, but if they can perform, then we're in breach. All right, so it's a remedy that isn't used very often, but it allows G'day Mate to say, okay, you can't deliver the skis, we'll buy some somewhere else. And then we come through with the skis, all right? Then they're in trouble. But it allows them to avoid the contract early. And the only difference between anticipatory avoidance here and avoidance under the buyer's remedy and seller's remedy is that's after a breach, okay? After they say, the date goes by and they cannot pay. Then we can avoid the contract. But if we anticipate that they're going to avoid the contract, that is a remedy, but it's also extremely dangerous. Okay, last factor to take into consideration is something common to both civil law jurisdictions and common law jurisdictions, and that's mitigation. The wronged party must act reasonably in attempting to reduce the damages suffered. So we're sending skis, 1,000 pairs of skis to G'day Mate, and they advise that they're going into insolvency or they can't pay. Okay, so now we're gonna launch a lawsuit against them. If we sent the skis all the way to Australia and then turned around and brought them all back, is going to be a huge cost, right? And that would be part of our damages. So we didn't get paid, and we lost the transportation costs. When we get into court, the judge is going to say, "What did you do to mitigate your loss?" And we go like, "What do you mean?" G'day Mate points out that a company in New Zealand wanted skis, and we were aware of that. And so we brought all those skis all the way back from G'day Mate and sent other skis out to New Zealand. When what we should have done, we should have diverted the skis from Australia to New Zealand, sell them perhaps at a lesser amount, okay? But we would have reduced the damages. So the cost, the damages we suffered from G'day Mate was, let's say $84,000. Diverting the skis and selling them in New Zealand meant that we recovered $74,000. Well, when we sue G'day Mate, we now sue just for $10,000 because we've mitigated our loss. If we don't mitigate our loss, we might not get any of our damages. Okay, so you have to mitigate your loss. Force majeure, we've already commented on. It's the failure to perform due to an impediment beyond the control of the party that's declaring force majeure, and the impediment was not foreseeable. Okay, so there was a shipload of material going to India, and the fastest way is to go through the Suez Canal. But there was about to be a war between Israel and Egypt. And everybody knew that they were on the verge of war, and the ship is heading towards the Suez Canal, and the captain in the business thinks, "Oh yeah, well let's just go ahead." So they got into the Suez Canal. The war broke out. The canal was blocked, and the ship was stuck in there. The company declared force majeure. The court denied it on the basis that, well, you were aware that there was a good possibility of that happening. Therefore, you should have diverted the ship around Africa and got it to India. That would have been longer, but you could have declared force majeure so that there was a delay in the time you had to deliver. But declaring force majeure when you knew something was going to happen doesn't work. Okay. But the example I used is if we were supposed to deliver skis to G'day Mate in Australia, and a fire next door in the building next door. Perhaps we're leasing part of a building and the fire in the other leased premises causes us damages, then we can declare force majeure, but only if there is a clause in the contract. Now, this is a definite civil law concept, but it is incorporated into the CISG. Furthermore, more common law countries, when they're entering into contract, are adopting this civil law concept and putting it into their contracts. So there's force majeure clauses. And on the next clause, or on the next slide, I show you a force majeure clause out of a contract. The thing you have to stop and think about is, the next slide deals with COVID-19. Does your force majeure clause cover the shutdown of your business due to COVID-19? And the wording has to be specific, because there have been some companies that declared COVID-19 outside their control, and the interpretation of the contract was such that it was not covered. Okay. The reason we adopt force majeure, and the reason it's in the CISG, is that the common law has this concept of frustration. Frustration is an excuse for non-performance because the performance originally agreed upon has become impossible. When the frustration occurs, it discharges the parties from performing their contractual duties in the future. It has to be, again, something outside your control. Otherwise, it's called induced frustration. And the problem with that is the contracts are generally discharged at that particular point. So if I have paid a deposit and you haven't sent the goods, frustration means I get to get the deposit and you don't get anything. And so there were all sorts of inequities with respect to the concept of frustration. Force majeure doesn't end the possibility that a contract may be frustrated, but what it does do is it says it can be suspended for a period of time in the hopes that we can actually complete the contract. Okay, now that concludes the discussion of contracts, and the next topic we get into, topic number 10, will be financing transactions. Thank you.